everyone, and welcome to this week's edition of our live web webinar series, proudly presented by ImmigrationQuestion.com, your trusted source for the latest immigration updates, expert legal insight, and live conversations with licensed attorneys. My name is Anusia Mukherjee, and I'll be your host for today's edition. H-1B transfers with pending green card applications, preserving priority dates, and navigating AC-21 provisions. If you are currently on an H-1B visa with a pending green card application, you already know navigating job changes isn't simple. It's not just about finding the right opportunity, it's about protecting your legal status, safeguarding your priority date, and avoiding delays that could set your case back by years. Today's session will cover key things you need to know if you're considering a job switch while your green card application is pending. From preserving your priority date to understanding the portability options, we'll walk you through the practical strategies to help you stay compliant and on track. To guide us in this process today, we're joined by attorney Nate Hanet and attorney Sonu Lal. Attorney Hanet is an immigration intake attorney at Eady and Associates out of New York City. He works every day to help people with a variety of immigration issues to ensure they get the services they need. Attorney Hanet previously worked as a criminal defense attorney, public defender, and prosecutor at a felony level in the state of Louisiana. He graduated from the Paul M. Herbert Law Center at Louisiana State University and with a Juris Doctorate in comparative law. And we're also joined by attorney Sonu Lal, who is an experienced business immigration attorney focused on helping employers secure work visas and green cards for skilled professionals. He handles H-1B, L-1, E-2, O, and EB cases across industries like tech, finance, and hospitality. A graduate of Cardozo School of Law, Attorney Lal is licensed in New York and a member of the American Immigration Lawyers Association, AILA. I welcome you both to the webinar. It's great to see you again.
Thanks for having me. It's a pleasure.
Thank
Thank
you.
you very much.
Before we dive in, a quick reminder. Immigration Question is a platform that connects users to immigration attorneys. We are not a law firm. All attorney services are provided independently by professionals registered to our network. And exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. So let's get started with the questions. Let's begin with something fundamental. Attorney Lal, this question is for you. If someone is currently on an H-1B visa, is it possible for them to transfer to an O visa? How does the process work?
So it happens quite often that people who are on H-1B somehow the current employer is no longer willing to continue that H-1B sponsorship, and then people in those situations they are left with very few options. In those cases, O1 fits very well where there is currently no uh, sponsor available, or for any reason that that particular employer maybe cannot sponsor you, or in some scenario person is not actually on H1, they are here on F1 working on their OPT, and they have not been selected in the H1B lottery. In all those scenarios, O1 works perfectly. Only thing is, practically speaking, the person should have some at least some experience, and for O1 purposes what they have to show is that they have extraordinary ability in their field. They can get recommendation. There are certain factors. Out of those certain factors, if the person can fulfill at least three, they can qualify for O1 visa, such as if they have been receiving salary in comparison to their peers, which is much higher, or if they have performed a lead role in a distinguished organization, etc. So in those cases, O1 can be an answer to people who currently not selected in the H-1B lottery, or were or on H-1B and the current employer cannot sponsor them for an H-1B.
Okay, thank you for that. Attorney Hanet, can you explain what exactly the H-1B lottery is and how does someone enter and what are the chances like to win the lottery?
Absolutely, and I apologize. This isn't a question that I had earlier or sent to me earlier. So I may need attorney law to supplement, but the H-1B lottery is simply like any other lottery system in the immigration court. You apply, you file your H-1B visa, and depending on whether your employer is capped exempt or not exempt, you would fall into the lottery or you would not. If your employer is not capped exempt, then you would fall into the lottery. So what would happen is you'd have to wait essentially until the lottery for you to get that visa. And I'll let attorney law kind of supplement with anything else.
Yeah, so every year in the month of March, USCIS would conduct a lottery. That's how the lottery works. There are 60,000 H-1B visas available each year. In addition, there are 20,000 H-1B visas um, for people who have a graduate or master's degree from the US. And there are certain other visa categories for people who are from Chile or Singapore. So total 85,000 H-1B visas are allocated each year. Since the demand is much more than the supply, and the application normally each year between 2 to 3,000 people apply for those 85,000 visas, and that's why USCIS every year have to conduct that lottery, and that's one part of it. And then once employer fill in the H-1B lottery, and then a couple of years ago it was converted to all electric, meaning you don't have to file anything physically. Everything happens online with respect to H-1B. So H-1B results are announced at the last week of March, and then whoever are selected, they are notified by USCIS, and they have 90 days to file the H-1B petition from April 1st to June 30th. Now, as I mentioned, the whole process has been converted to electronic format. Before it was being electronic, the process was the employer will have to prepare the H-1B petition physically on papers, submit it to USCIS. USCIS will do a lottery. Whoever were selected in the lottery will be processed. Whoever were not selected, their H-1B petition, the actual hard copy, will be returned to the employer. It was very cumbersome process, costing a lot of money, costing a lot of time, resources from the both sides, from the employers as well as from USCIS. So it was a very crucial, very wise decision on the part of USCIS to convert this process to electronic. And now, once you are selected, you file the H-1B petition, and if you are approved, the petition is effective, meaning the person will be authorized to work from October 1st. If you are already in the US in some other status such as F1, your status will be changed from F1 to H-1B effective October 1st. If you are outside US, once it is approved, you will apply for an H-1B visa at the US consulate or embassy. And after you get the visa, you can travel to US, come and work for your employer from October 1st. And it will be initially for 3 years. After 3 years, if the employer wishes, you can continue your H-1B for another 3 years. That's how the whole H-1B lottery works.
Okay, thank you. I think to follow up with that question, can someone sponsor themselves for the H-1B visa if they've set up their own organization or company, attorney law?
So it's a great question, and then we get this question a lot, specifically since the law changed this year from 2025. Typically, you can only work for the employer who sponsored you for your H-1B visa. But with the change in law in January 2025, what you can do is if you want to, let's say you are on H-1B and you want to start your own business. What you can do is you can incorporate your own company. You can either be 100% owner or you can be a part owner in that company. And if you are a sole owner or a 100% owner in that company, then strategically what you can do is you can file a concurrent part-time H-1B to work for that company initially. And as per the new rules, the initial H-1B for that company would be for 18 months. Typically, H-1B is approved for 3 years, but in this, with the new law, If you are the owner of that company, the H-1B for 18 months. And once the business is operationalized, then probably you can convert that concurrent part-time H-1B to a full-time H-1B, and you can probably leave your current job and be 100% on your own company. So theoretically and maybe practical purposes, it's like self-sponsorship. And then you can extend it for another 18 months. After the first extension, the next extension, meaning the second extension, can be for a regular 3 years. So initially it will be for 18 months plus 18 months, and after that it will be regular 3-year extension. But the bottom line is with the new rule, you can self-sponsor yourself and have H-1B filed through your own company, which was not before January 2025.
Okay, thank you, Attorney Lal, for that insight. I think Attorney Hanet, I wanted to ask, let's tackle a question that we get a lot from our immigration forum. So, if a person's status lapses, how long can they actually continue working before it's a serious problem?
Well, I would say for as long as their work permit would allow, but I'll let Attorney Law kind of supplement my answer as well.
So typically it will be
Recall
for
period.
3 years. Typically it will be
As
for
long
three
as
years.
the work permit hasn't lapsed, and as long as they are in the process of filing, to maintain status, I think they would be okay. But I'll let Attorney Law supplement.
Typically it will be for 3 years, but there is a thing called availability of
Can y'all
work.
hear me?
If the employer uh, can show that the employer has availability
Hello?
of work for 3 years, the H-1B will be for 3 years. If not, it will be for a shorter duration.
Okay, thank you for that. I think Attorney Hanet is having some technical issues. Um, my next question would be, can someone on an H-1B visa legally work two jobs at once, or is that a no-go, Attorney Lal?
No, it's a great question, interesting question. Sometimes it happens if you are working on H-1B visa, you sometimes get another job offer. And since you are H-1B visa, many people assume that I am only authorized to work for my current employer, and I cannot have two jobs since I am on H-1B visa. That's not true. You are allowed to work for multiple employers, even if you are on H-1B. Only thing is, the new employer will have to file another H-1B.
Mm-hmm.
And practically, how we do it is the new H-1B or the H-1B with the second employer can be filed as a concurrent part-time employment.
Mm-hmm.
So let's say you are working with company A as a full-time H-1B, but you get another job.
Mm-hmm.
It's a part-time job. So the new employer, employer B, can file a concurrent part-time H-1B, and you can have both the jobs at the same time, even if you are on H-1B visa.
Okay, thank you for
And,
that.
and just FYI, we have filed so many of such cases.
Mm-hmm. All right, thank you so much for that. Um, To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you. We are immigrationquestion.com, a two-in-one platform built with lead and case management to help simplify the immigration process. You can ask your immigration questions for free in any language and get connected with a verified attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigration.question.com and sign up today, or you can even download our app. So, Attorney Hanet, this is for you. As a trusted legal professional working closely with both documented and undocumented immigrants, how do you view the role of the platform like immigrationquestion.com in supporting and empowering the immigrant community today?
Oh, it's fantastic. It is absolutely fantastic. For immigrants, for people in this country, to have a resource like Immigration Question, who connect them with the attorney that they need, is absolutely vital. Especially in these times under the current administration, you really want to make sure that you get as much assistance as possible. And one of the best ways to do that is through a service like Immigration Question. It's here to help you. It's not here to cost you any money. It's here to make sure that you get in touch with the attorney who's best suited for your case. So I can't recommend services like this enough. It's really it's one of the best things that someone who's just gotten to this country or who's been here for a long time can really can use to prepare and to protect themselves.
And thank you, Attorney Hanet. Attorney Lal, since you've been on this platform so many times, what do you think is the biggest highlight of our platform and that we have a new app coming in?
I think the biggest highlight is it connects both the parties, meaning the attorneys and the people who are looking for attorneys. So in that sense, it's a great platform.
Thank you so much. Before we jump into our Q&A session, I wanted to ask Attorney Lal, what is one golden piece of advice you would give to people navigating H-1B transfers with pending green card applications?
It's a great question. And if you are transitioning to a new employer and the current employer has already started the green card application, in that case, I normally advise people stick to the current employer until 180 days have passed since the approval of your immigrant I-140 petition. Because you can have all the benefits even if the employer withdraws the I-140 petition. You can extend the H-1B, your H-1B visa, and you can retain that priority date for future I-140 purposes. So do not leave your current job until 180 days have passed since the approval of your I-140 petition.
Thank you, Attorney Lal. To our audience, the floor is now open. Drop your questions in the chat, and Attorney Lal or Attorney Hanet will answer as many questions as possible. If you'd like to call us live and ask directly, call 516-703-3483. All right, our first question is, I think Attorney Lal, you'll be able to answer this. I'm planning to change jobs soon. What happens to my H-1B sponsorship if I move to another company? Does my new employer have to start the whole process over again?
So the answer depends upon at what stage the current employer is in the green card application. So if the current employer is only at the stage of labor certification, then yes, the new employer will have to go through the labor certification process again. And you won't be able to retain that priority date even if they have filed the labor certification. But if you already have an I-140 approved with the current employer and 180 days have passed, then when you switch to the new employer will still have to do the labor certification process again and I-140 again. But the good part is, as long as that process is pending with the new employer, you can still extend your H-1B status beyond 6 years, number one. Your spouse can still get an EAD based on the previous I-140. You do not need a new I-140 from the new employer. And number three, you can still retain the priority date listed on that I-140. Having said that, the new employer will still have to go through the labor certification process again. Only in one scenario, the new employer will not have to do the labor certification, where you have already filed I-485 based on your priority date being current, and 180 days have passed since the filing of your I-485 green card application. In that case, the new employer will only have to file what is called I-485 Supplement J and will not have to go through the labor certification or I-140 process again.
Okay. Thank you for that, Attorney Lal. Next question is, I'm currently on an H-1B and my employer just filed for PERM perm. Will this help me get an H-1B extension or do I need to go through another process? I think, Attorney Lal, this is for you again.
So typically, if the perm is pending and you are approaching a 6 year deadline of your H-1B, it can only help you get an extension in the increment of only 1 year. So the employer can file an H-1B extension, but they can only request 1 year of extension instead of 3 years. That's the only benefit of a pending uh, perm applications. In these cases, what I advise people normally do the extension for at least 1 year, and as soon as the labor certification is approved, have the employer file the I-140 with premium processing rather than regular processing. And once the I-140 is approved, you can get a regular 3 year extension.
Okay, thank you. And our next question is, I'm on an H-1B visa and I've been wondering, can I bring my wife and kids over here with me? Will that affect my current status at all?
So if you are an H-1B visa, the regulation allows you to bring your family along. If they are abroad, what they have to do is they have to schedule an appointment for H-4 visa based on your approved H-1B petition or H-1B visa. They will go for an interview, they will get the H-1B visa stamp, and they can come back. And it will not affect your H-1B status.
Okay, thank you. Next question is, I've heard about something called the H-1B transfer petition. What exactly is that? Is that the same as starting a fresh H-1B application?
So the difference between fresh H-1B application and transfer petition is that if it is initial or fresh H-1B, then you have to go through the H-1B lottery. And only if you are selected in the H-1B lottery, the employer can file the initial H-1B. Now, for H-1B transfer, you don't have to go through the H-1B lottery again because you have already been counted or you have already been gone through the H-1B lottery process. So you would just simply, the employer would just simply file your H-1B petition or H-1B transfer petition with USCIS without going through the H-1B lottery. So that's the difference.
All right. And then our last question is, if you see it on the screen, my H-1B extension is set to expire in a few months. What should I do? What should I be doing right now to stay on top of it or avoid falling out of status?
So before the expiry of your current H-1B visa, you can have your employer file your H-1B extension 180 days before your I-94 expires. And once they file it, you should be fine.
All right. I think that's all our questions. So thank you, Attorney Lal. Thank you, Attorney Hanet. That was an excellent way to end our session. Thank you so much for joining us, and a special thank you for the both of you to give you your
Thank you,
insights.
Aaron.
This has
Thank
been a
you.
burning topic. Uh,
Thank you.
we hope the webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with the licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our site to learn more. Don't forget to you can rewatch this session or listen to our previous episodes on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening edition regarding another burning immigration topic. Trust us, you won't want to miss it. Once again, Attorney Lal and Attorney Hannah, thank you so much for joining us, and we hope to see you again.
Thank
Thank
you.
you.